Hi there, this is Simon, personal finance coach. The current life expectancy in the US is 75 years for men and 80 years for women. And although the life expectancy is increasing and some people die much younger for many reasons, eventually each of us is going to pass. As we pass, the hassle and the cost to your family as they deal with the passing can be enormous. The main factors that contribute to the hassle and cost include complexity of assets, the probate process, debt and tax obligations, and family disputes. The process can cost thousands or tens of thousands of dollars, and it can take years to settle an estate. Half of Americans that don't have an estate plan, but most people do, who have assets exceeding several hundred thousands of dollars, have wills, and they have trusts, or multiple trusts, because different trusts accomplish different things. There are many issues to account for when creating a will and a trust, but this video is about what you should consider in naming an executor and trustee and how you should handle this responsibility if you are named as one. Before we continue, please subscribe to this channel to receive notifications on future videos. Most importantly in estate planning is to have a will and a trust if justified and not to die intestate, which is a fancy word for dying without a will. If you die intestate, the government is going to impose a boilerplate document for you to use. The problem with dying intestate and defaulting to government documents is that they not be leaving your assets to who you would want to leave them to. And the assets are not only your bank accounts, brokerage accounts, and financial assets. The assets are also personal items of sentimental value in addition to those of financial value. A will is simply a document that describes who gets what. A trust is a document that describes special circumstances and conditions of who gets what, when, and how. Some examples of special circumstances might be the someone you leave the money to may not manage it properly, or they may be scammed by somebody who would take advantage of them, or someone that would blow through the cash quickly and irresponsibly, or someone that has special needs and does not have the capacity to manage assets, or someone that has a drug or alcohol addiction, or someone that is married to somebody you don't trust. For any of those or any other reasons, you can prescribe the conditions on which they get the money or the asset. You might decide to give them a monthly allowance or delay them receiving the money to when they reach age 20 or 30 or 50 or what have you. You might decide to limit the reasons they are allowed to receive money, such as for healthcare or education or to buy a home. So in a trust, you can dictate who gets what, under what conditions they receive it, the timing that they receive it, and so on. It gives you, the grantor, the choice to do all this in advance. The most fundamental issue that you have to address ahead of time in creating a will and a trust is who will be your executor and who will be the trustee of your trust. If you have a will, you have to name an executor. Executor is responsible for managing and settling the estate of the deceased person according to the will. The duties typically include identifying all the assets and debts, filing with the court, settling debts, paying taxes, and distributing assets. If you have a trust, you have to name a trustee. Trustee is responsible for managing the assets in the trust and settling the assets according to the instructions in the trust. The executor and the trustee can be your adult child, a family member, a trusted friend, a professional such as a lawyer or accountant, or a corporate trustee like a bank or a trust company. If you think there might be disputes or conflicts between the beneficiaries, you might be better off choosing a trustee or executor outside the family circle. Keep in mind that trustees and executors that are not beneficiaries are typically entitled to compensation for their services. It is also fairly common for the executor and trustee to be the same person or entity to simplify the administration of an estate. So as a grantor, you make a choice of executor and trustee. What do you want to have in an executor and trustee is credible skills such as trustworthiness, organization and attention to detail, financial acumen, impartiality, location proximity, willingness, availability, and ability to serve. Being an executor or trustee might be a stressful and somewhat difficult task, especially if conflicts arise. If there are heirs that are unhappy with how much did they get or did not get, or unhappy with how you're handling the asset disposition, they might sue you. The job comes with personal liability for your actions. If you distribute assets out of the estate to somebody and then another person comes along demanding the money and you've already given it away, you're liable for that. And if you have accepted the role, you want to make sure you're doing everything possibly to minimize your own personal liability. If you suspect that you might become the executor or trustee of somebody's estate one day, let's say your parents, ask them while they are alive, who are they naming as executor and trustee? So if you're going to be assigned to this role, ask to see those legal documents in advance. This will give you an opportunity to look over them and ask questions to mom and dad about what they meant and what their intentions were. This helps to eliminate the ambiguity or omissions and lets mom and dad give you the information before they are gone, and you'll never be able to ask any follow-up questions. Also, make sure you are aware of what you're in for. Make sure you're making an informed decision about agreeing to serve. And if you find yourself accepting the role, you want to make sure you're doing everything possible to minimize your own personal liability. And what that means, that the first thing you want to do when the time comes is to hire an attorney to help you deal with the disposition of the will and the trust. Hiring the attorney that drafted the will and the trust might be beneficial. You need, at the outset, to notify Social Securities to stop payments and to notify life insurance companies if there are any. If you want to terminate subscriptions and other expenses that are obviously no longer needed. There is no need to worry about the debt that the deceased owed that you are not aware of, because death request letters will come in mail. You might have to file with the probate court. In general, if you have a trust, you do not need to file with probate court. However, there are some exceptions, such as if the trust was not properly funded, probate may be necessary. If there is no trust, there are legal minimums in each state on the value of the estate in order for it to be required to go through probate. Probate allows creditors to come forward if money is owed. It gives an opportunity for disgruntled or omitted heirs to come forward making claims as well. The probate process can take a while to complete. 1 year is not unusual. Asset distribution process takes some time as well. So with the help of the attorney, you'll go through the process. There is no need to rush or take any urgent actions, especially while the family is dealing with the grief and sorrow of the passing of the loved one. And one final point, you are allowed to obtain compensation for your services. In many states, there are statutory guidelines for executor compensation based on the value of the estate. And the attorney fees are paid from estate assets as well. Please subscribe to this channel to receive notifications on future videos, and thank you for watching.